in the matter of British Broadcasting Corporation and the BBC Pension Trust Ltd and another.
My Lords, my Ladyship, in this matter I appear for the appellant, the BBC, together with my learned friend Mr. Edward Sawyer. My learned friends Mr. Brian Green, KC, and Mr. Joe Stedman appear for the first respondent, which is the BBC Pension Trust. The second respondent, Miss Christina Burns, is represented by my learned friends Mr. Andrew Spink, KC, and Mr. Saul Margot. The appeal concerns the scope of the power of amendment under the BBC pension scheme. The second respondent is representing those active members and other beneficiaries of the scheme who may benefit from establishing the narrowest possible scope of the power of amendment in relation to the issues raised by the proceedings. I shall refer to her as the representative beneficiary, and the BBC is representing all other beneficiaries of the scheme. By way of background, the BBC's reasons for wishing to clarify the scope of the power of amendment under the scheme are summarised in footnote 2 of our skeleton, which is at page 22 of the core bundle, and is based on the evidence at first instance. In brief, at the time of the last hearing, the BBC's contribution rate under the scheme had almost tripled since 2010, with the result that 80% of the BBC's current spend on pension provision was being made in respect of DB employees who constituted less than 40% of the workforce. Although the representative beneficiary in her skeleton makes the point that the BBC's contribution under the scheme has fallen somewhat, the BBC is still being required to contribute at the rate of 30% of the total cost of pensionable salaries. And that rate of 30% is double what it was in 2010 when the BBC last attempted to reform pension benefits. 30% is also many times higher than the contribution rate of 7 or 8% of pensionable salaries that the BBC pays in respect of post-2010 employees who are members of a separate DC plan. Although the second defendant suggests that the evidence as to the commercial difficulties which the current benefit structure gives rise are irrelevant to the legal issues in the case, in my submission the increases to the cost and indeed the volatility of DB funding for the BBC in recent years represent exactly the sort of exigencies of commercial life which powers of amendment are usually there to address. Yet on the judge's interpretation of the third proviso, they can't be addressed under the amendment power, as the benefit structure, which dates from 1949, cannot be amended for future accrual unless there's compliance with the very restrictive exceptions to the third proviso. The third proviso to the power of amendment is found at clause 19.2 of the current deed. I won't go to it at the moment. Suffice it to say that, as your Lordship and Ladyships will have read, subject to certain exceptions, the third proviso restricts amendments that, quote, take effect as regards the active members whose interests are certified by the actuary to be affected thereby. And the issues on this appeal therefore turn upon what the draftsman meant when he referred to the interests of active members which were to be the subject matter of the actuarial certification. The order of the judge dated the 28th of July 2023, from which the BBC appeals, can be found at page 85 of the core bundle at tab 6, and I do propose to just briefly take the court to that. You'll see, picking it up at the bottom of page 85, the judge answered various questions asked in paragraph 1A to E of the claim form as follows. In relation to question 1A, which was whether on the true construction of the third proviso the interest of active members refers to the rights of those members earned by past service up to the date of any amendment, the judge answered yes, and that's over the page on 86, and that indeed was common ground between the parties. In relation to question 1B, he declared that the interest to be certified also protected what's known as final salary linkage. However, this declaration was subject to a rather significant caveat, in that his full answer was that that was subject to the qualification that in relevant cases the linkage between past service benefits and final pensionable pay, calculated by reference to such part of an active member's future salary and wages, is calculated by reference to such part of an active member's future salary and wages as may, consistently with the Court of Appeal's determination in Bradbury versus the BBC, be determined by the claimant, that's the BBC, to qualify as basic salary. And that caveat gave effect to the Court of Appeal's 2017 decision that the BBC already has a power to determine that increases to members' basic salaries should not form part of the calculation of the members' past service pensions. In relation to questions C and D, the judge answered yes to the question of whether the member's interest also included the ability to earn further benefits through future service, and yes to the question of whether it was possible, that also protected was the ability to do that on the same terms as existed before the amendment. And on the basis of the answers to those questions, the judge didn't see the need to answer question E, as no other potential restriction on the third proviso had been canvassed before him. And just for completeness, at paragraph 2 of the order, the judge found for the BBC on the remaining question argued before him, which was as to the proper purpose of the power of amendment. As you will have seen from the appellant's notice, which is at tab 4 of the same bundle, the BBC is appealing the orders made at paragraphs B to D of the judge's order, namely the findings that the member's interests to be certified by the actuary protected the possibility of accruing further benefits under the scheme as a result of future service on the same terms as currently, and secondly, the linkage of benefits with any future salary increases granted to the member. There is no cross-appeal on any part of the order made by the judge. It follows that both respondents accept, like the judge, that Bradbury versus BBC did decide that the amendment in 2000, which gave the BBC the power to determine that increases to members' basic salaries should not be linked to the calculation of members' benefits, was a valid amendment of the scheme. Instead, the issue between the parties in relation to BBC and Bradbury is as to how the Court of Appeal came to that conclusion and whether such reasoning was consistent with the interpretation of members' interests adopted by the judge and in particular his conclusion that the third proviso did protect future salary linkage. I propose to deal first therefore with questions C and D and the issue of whether the possibility of the member earning further benefits through future service on the same terms as currently is protected by the third proviso. In summary, the BBC's position is that the potential for the member to accrue further benefits through future service is not an interest of the member which has to be certified by the actuary and is therefore not protected by the third proviso, nor is the potential to accrue future benefits on the same terms as currently such an interest. It follows that on the BBC's case, it is open to the trustee and the BBC acting together to exercise the power of amendment so as to modify the rate of future accrual, terminate future accrual, or indeed change the terms on which future accrual is permitted, such as the rate at which future contributions are paid by the member. Now, as we state in our grounds of appeal, paragraph 1.2, in our submission, the interests which are protected by the power of amendment are the bundle of legal rights and entitlements to benefits under the scheme that have been earned by members through past service at the time of amendment. As a shorthand, and to distinguish our meaning of interests from the much wider meaning of interests adopted by the judge, we describe that bundle of rights and entitlements as the member's legal interests. That phrase is merely a shorthand. As the courts will appreciate, all the rights to different benefits earned by an active member under a pension scheme are, while he remains an active member, contingent on what will happen to that member in future, i.e. whether that be retirement, death, early retirement, late retirement, or leaving service early. They depend on what happens in the future. So, as an example, as the judge recognised at paragraph 18 of his judgment, an active member's right to a pension at 60 based on past service is contingent on what happens to the member in future, and in particular whether he survives to the age of 60. Now, because the bundle of different contingent rights to benefits granted to a member under a pension scheme generally covers most or all possible contingencies, it ensures that the member will benefit in some way from his, or generally ensures that the member will benefit in some ways from his past service under the scheme, even if the precise way in which he will benefit is currently unknown. He may survive to 65 and receive a pension, he may die early, he may take a pension early, he may suffer from ill health. Those contingencies are also potentially covered by pension benefits. Now, it is the actuarial impact on that bundle of rights which the BBC says are required to be certified by the actuary under the third proviso to the power amendment. They represent the members' interests. Now, although the representative beneficiary argues that the potential to accrue further benefits through future service can also be described as a legal or present right, in my submission there is a clear conceptual difference between an existing right to a benefit, even one that's contingently payable, for which consideration in the form of past service has already been provided, and the potential, on the other hand, for a member to earn such a right in the future by providing further service. The latter cannot sensibly be described as an existing right to benefits. Indeed, as we shall see, in relation to future service benefits, the member does not even have what can be described as a right under the scheme to accrue such benefits, insofar as the ability of the member to do so is subject to powers under the scheme to stop the accrual of benefits and also terminate accrual, and also, on the BBC's case, to amend the scheme so as to change that rate of future accrual. Before turning to the provisions of the third proviso, I'd like to say a few introductory words about the approach to pension scheme construction in cases of this nature. And I would like to briefly address 3 points. Firstly, the relevance and significance of the 1949 deed. Secondly, the weight to be attached to a textual analysis compared to the admissible factual background in the process of construction. And thirdly, I'd like to make some general submissions about the approach to the construction of powers of amendment in pension schemes. Now, starting first with the significance of the 1949 deed, there is not, in fact, a huge disagreement between parties as to the applicable approach, only perhaps a difference of emphasis. All parties accept that the wording of the third proviso and the rest of the power amendment is materially the same now as it was in the 1949 deed, in which it was first introduced, and that its meaning has not changed since then. Given that everyone accepts that the meaning of the provision has not changed since its introduction, in my submission it makes sense chronologically to start with by looking at the deed in 1949 before asking whether anything happened since then to change or reinforce that meaning. In my submission it is also illuminating to consider the meaning of the third proviso in the context of the 1949 deed and rules in particular, because as your lordships will be aware, that was a brand new document with all the provisions having been drafted and introduced at the same time. In other words, that deed was not, as is sometimes the case with pension schemes, a patchwork quilt document built up by different amendments at different times over many years. It was a homogeneous document whose structure and drafting and language was the product, whose structure and language was the product of a unitary drafting exercise. And those provisions were obviously intended to be a complete and internally consistent guide to how the scheme should operate. Further, while there's certainly no rule of law that one has to start the process of construction of a provision that's been adopted and re-adopted a number of times by starting with its meaning in the...
Sorry, just pause there. When you say re-adopted, in the case of this deed, the process has actually just been a series of amendments. Is that right? Has there been any formal readoption.
Well, insofar
maybe
as
maybe it's a distinction without a difference.
It may well be, your ladyship, because obviously if you say, well, from henceforth, I'm now going to, for example, as happened in this case, change the word member to active member for the process of clarification, you are implicitly, I think, readopting the existing provision with that change. Right,
but there's been no wholesale replacement of just as a matter of technique. There's just been a series of deeds of variation rather than a wholesale replacement.
Yes, they are replacement deeds, but they purport to restate the provisions of the 1949 deed. So the position is actually quite. We'll actually go to one where I'll show you how it's put, but the new deed purports to be the 1949 deed as amended. So. Now, given that I don't believe there's a significant dispute between the parties on the effect of the case law, well, I don't propose to take the court through the Court of Appeal's earlier decision in Stenaline and MNRPF trustees in any detail. The relevant passages have been sidelined, and I expect your lordships and ladyship will be familiar with it in any event. If we just turn, there's just one point I think I can usefully point to in it. It's at page 318 of the first authorities bundle at tab 14. It concerned the construction of a power amendment that had been readopted in various deeds, and the Court of Appeal construed the meaning of the power in the context of a 2001 deed, which was the point where certain employers had ceased to make contributions to the scheme. And they did so notwithstanding that the provision had subsequently been readopted in a 2007 deed, and it was the 2007 version of the power that was being proposed to be exercised. And you get that generally from paragraphs 33 to 35, which have been sidelined. The only point I want to refer to is the last sentence of paragraph 34, where Lady Justice Arden says, the more likely inference, however, from the readoption of a clause without any material change is that the clause retained its meaning without any material change. And we say that's the inference to be drawn in the present case. I do want, however, to look at Buckinghamshire and Barnardo's in a little more detail. And that authority can be found at bundle 3 at page 771. And that's divider 27. Barnardo's is not only the leading case on the question of pension scheme construction, it's helpfully relevant to both the question of the use to be made of prior deeds and the weight to be attached to a textual analysis compared to the admissible factual background in the process of construction. Looking first at the question of the use to be made of prior deeds, nothing in Barnardo's casts doubt on the appropriateness of the approach suggested by the BBC in this case of starting the process of construction with the original deed in which it was first introduced. On the contrary, that is exactly what both the Court of Appeal and the Supreme Court did in Barnardo's. Although on the particular facts of Barnardo's, the Supreme Court found no real assistance in looking at a prior version of the rules from 1978, that was only because the 1978 provisions were in a completely different form. If we pick the report up at paragraph 1, people see that the appeal raised what became quite a common question as to the construction of a power by the trustees to change the prices index by reference to which pensions were increased. But the background facts are at fore in relation to the different deeds which were before the court. Paragraph 4, Lord Hodge says, in 1984, Barnardo's adopted a staff pension scheme which took effect from 1978. In 1991, Barnardo's adopted a new pension scheme which took effect from the 1st of April 1988 and completely superseded the 1978 scheme. The 1988 rules have subsequently been amended and adopted with effect from 2001, 2004 and 2007. But the relevant provisions of the current rules are in substance the same as those in the 1988 rules, to which Council referred in their submissions. I have therefore set out the relevant provisions from the 1988 rules. And it's clear from that that the Supreme Court itself did decide to construe the meaning of the provisions by reference to the original deed in which they were introduced, because they were in substance the same, and the rules that were disregarded as bearing on construction were the original 78 rules, which were described by Lord Hodge as a separate scheme. It's also clear that the Supreme Court then proceeded to derive the meaning of the post-1988 iterations of the rules by ascertaining what the similarly worded provisions in the 1998 and the 1988 rules meant when first introduced in 1991, and against the admissible factual background to the 1991 amendments. Thus, in paragraph 7, your lordships and ladyships will see that Lord Hodge refers to an appendix to the 1988 rules, which summarised the Inland Revenue requirements at the time the 88 rules were introduced. And the significance of the reference to the old Inland Revenue guidance is that guidance had been superseded in 2006, so was no longer extant when Barnardo's was decided. Nevertheless, it was the fiscal background at the time the rules were drafted. Furthermore, having stated his conclusions as to the meaning of the relevant provisions at 19, Lord Hodge then sets out his reasons for reaching those conclusions. And at 22 D2E, D2E, those reasons include an analysis of the factual matrix at the time of the introduction of the 1988 rules in 1991, including the number of inflation indices in existence at the time and the state of the UK gilts market back in 1991. Now, as I've indicated, Barnardo's is also relevant to the weight to be attached to a textual analysis compared to the admissible factual background in the process of construction. And in relation to that issue, the court will see that at 15, paragraph 15 on page 776, Lord Hodge noted that the characteristics of a pension scheme that he'd recited at paragraph 40 meant that more emphasis should be placed on a textual analysis of a document and perhaps less weight on the factual matrix at the time of its introduction than might be the case in relation to a commercial contract. However, Lord Hodge was plainly not saying that one should therefore try and discern the meaning of words in isolation from their context, or the purposes of a provision, or in isolation from the purposes of the provision in which they appear. A textual analysis is an exercise in divining the meaning of words in the context of the provisions of the deeds in which they appear. Further, he goes on to note at paragraph 16 that the emphasis on textual analysis as an interpretive tool does not derogate from the need to avoid undue technicality and to have regard to the practical consequences of any construction. Such an analysis does not involve literalism, but includes a purposive construction where that is appropriate. Lord Hodge then endorsed the observations of Mr. Justice Millett, encouraged, which will return, to the effect that wherever possible, provision should be construed to give a reasonable and practical effect to the scheme. Now, the passage in Safeway, which is quoted and endorsed in paragraph 15 of Lord Hodge's judgment, simply makes the point that one should be slow to depart from plain language or to adopt a strained construction on the basis of background facts that would not be known to a pension scheme member. However, as we have seen, Lord Hodge's caution about not over-relying on background facts to rewrite the meaning of provisions as a matter of textual analysis did not prevent him, as we've seen, from analysing the relevant provisions of the 1991 rules in Bernardo's by reference to the then factual background. Plainly, therefore, provided such matters are not given primacy over the text so as to result in a departure from the plain meaning of the words used, Lord Hodge saw no objection to considering background factual matrix. Just to be clear, however, this is not a case where the BBC is inviting this court to depart from the plain meaning of the phrase interest to be certified by the actuary on the basis of a set of arcane background facts to the 1949 deed or the current deed, which would be unknown to a current member. On the contrary, the BBC is simply inviting this court to consider what the draftsman meant by the reference to members' interest to be certified by the actuary in the context of the deployment of similar phrases and concepts elsewhere in the 49 deed and the current deed. At paragraphs 24 and 25 of their skeleton, those representing the representative beneficiary draw attention to the fact that Lord Hodge endorsed at paragraph 26 of his judgment the point made by Lord Justice Lewison in the Court of Appeal in Bernardo's, that the court should be reluctant to look at prior rules, as later joining members of pension schemes might have no knowledge of those rules. However, for the reasons already explained, what Lord Hodge meant by the prior rules at that point was not the 1988 rules to which he clearly did have regard, and indeed construed, but the rules of the predecessor 1978 scheme, which Lord Hodge had made clear had been completely superseded and rewritten by the 1988 rules. And if we turn briefly to the Court of Appeal decision in Bradbury, for good measure, you can see that that was also what, in my submission, Lord Justice Lewison meant when he referred to prior rules not assisting him. Bradbury in the Court of Appeal is at tab 21 of Authorities Bundle 2. Sorry, 23, I apologise. And so sorry. I beg your pardon. I'm intending to refer to the Court of Appeal in Bernardo's, which is at tab 21, which was the judgment of Lord Justice Lewison in Bernardo's, to which Lord Hodge referred back in his judgment in the Supreme Court. So could we pick up Bernardo's in the Court of Appeal, which is at 21. And you can see right at the outset, from the first paragraph of the judgment of Lord Justice Lewison, that he himself construed the definition of RPI and the power in the context of the 1988 rules, notwithstanding that, as was recorded by Lord Hodge in the Supreme Court, those rules had been amended and readopted by new deeds in 2001, 2004 and 2007. And thereafter, and consistently, like Lord Hodge, Lord Justice Lewison construed the relevant provisions in the light of the factual matrix in 1991 when those provisions were first adopted. And you get that by looking at paragraph 15 of Lord Justice Lewison's judgment. And paragraph 15, he starts by saying something about the indices which were in existence at the time when the 1988 rules came into force.
Mr. Tennant, my memory may be a little hazy about this case, but my memory is that the 1988 rules were the rules that were still in force when we had to construe the rival interpretations of replacing the index. They had, it's true, been amended, but they were still those same rules. And I think that's what Lord Hodge meant, is it not, when he said the rules are still the rules?
I had taken from what Lord Hodge said about the rules being adopted to be that they had been re-adopted. But that is certainly something we can go away and clarify.
Which is also linked to my earlier question, because as my Lord says, in this case, it's not very clear to me whether these rules have been re-adopted. And clearly we've got a case here where the clause itself has been subject to some amendment since 1949, so it may be a distinction without a difference.
Yes.
But in the case we're looking at now, had the clause itself been amended?
Yes, it's subject to the very light amendments.
No, sorry, being unclear. In the judgment we're looking at the moment in tab 21.
Well, I thought that the in the Supreme Court's decision, Lord Hodge said the rules were in substance the same, which indicated to me they were not the same rules. But so if you look at paragraph 4 of tab 27 of Authorities Bundle 3, you'll see what led me to believe that the rule was not in its original form, where Lord Hodge says the 1988 rules have subsequently been amended and adopted with effect from 2001, 2004 and 2007, but the relevant provisions of the current rules, which doesn't suggest it's the original rules, are in substance the same. So he's not saying, it doesn't appear to be saying, they're the same. If we just move on from Bernardo's, if that is I don't think we can take the facts at the moment of that case any further. In my submission, in any event, there's no doubt cast in Bernardo's on the decision in Stenner and MNRPF, and there have been several cases since Bernardo's, including at Court of Appeal level, which have ascertained the meaning of successively readopted provisions by considering the meaning of those provisions in the context of the deed when the provision was first adopted. And those cases are Britvik, Ove Arup, and Atos at tabs 33, 32 and 30 respectively of the Authorities Bundle 3. And perhaps I can simply therefore go to what was said in Britvik at Authorities Bundle 3, tab 33 on page 910. can see again, this was a case from paragraph 1 which concerned the construction of a power to change the index by which the rate of increases of pensions was mentioned. And then if we go to page 60, paragraph 65 on page 928, the judgment of Lord Justice Nugent, where he says, we are only concerned on ground 1 with the question of the construction of this rule. Strictly speaking, the question arises in relation to each of the iterations of the rule in the 2003 deed, the 2007 deed, and as amended by the 2008 deed, and in relation to each case to each of the 2 DB sections. But it was not suggested either before the judge or before us that the meaning differed as between the various iterations or as between the 2 sections. It is established law that where the very same provision is adopted in the same form, its meaning may in principle change if the context is materially different. But there is nothing to suggest here that the context was materially different, save for the introduction of the 2.5% cap in 2008, which does not affect the present question. I can therefore concentrate on the construction of the 2003 rules. And indeed, the judge then did construe those rules by reference to the circumstances in 2003 when it was adopted. So in that situation, again, there was a situation where it had been adopted, re-adopted, and indeed there had been minor but inconsequential changes, but the Court of Appeal still focused on the meaning at the time of its first introduction. So, for good measure, in our skeleton, we also make the separate point that there are reasons to start the process of construing a power of amendment, in particular, by looking at the provisions in the context of the scheme where it first appeared, and that's because there are conceptual difficulties with the concept of changing the scope of a power of amendment by the exercise of a power of amendment itself. But again, I don't want to labour this point. It's not a rule of law. All I'm advocating is that it's helpful and common sense to start from the 1949 deed, and so I won't propose at this stage to go through the cases on that topic, which we've listed in the skeleton. The final point I want to make in relation to construction is that it is obviously permissible to take account of the overall purpose of the clause and of the document in which it appears. And although it wasn't sidelined by the parties, a concise statement to that effect can be found at paragraph 15 of Arnold and Britton, which is at Authorities Bundle 2, tab 18. And in this regard, it's also important to have regard to what was said in Courage about the purposes of powers of amendment in the judgment of Mr. Justice Millett, which we quote in full at paragraph 17 of our skeleton. So having made the point, which was approved in Bernardo's, that pension schemes should be construed to give reasonable and practical effect to their provisions, Mr. Justice Millett went on to make clear that in relation to a power of amendment, that meant it was, quote, important to avoid a construction that unduly fetters the power to amend the provisions of the scheme, which would prevent parties from making those changes which would be required by the exigencies of commercial life. Now again, to head off at the outset any suggestion from the representative beneficiary to the contrary, the BBC is not saying, on this or any other basis, that the court can adopt a strained construction or depart from the plain meaning of language used. We obviously accept the correctness of both Bernardo's and Safeway on that point. Rather, the point we make is that if the court accepts that the reference to members' interests being certified by the scheme actuary is perfectly capable, as a matter of ordinary language, of bearing the meaning for which the BBC contend, which in my submission it plainly is, it is perfectly permissible to take account of the fact that the purpose of that power of amendment is to deal with the exigencies of commercial life, such as the cost and volatility of DB accrual, and to avoid unduly fettering the ability of the trustee and the employer to use that power. Now, that's all I want to say on construction generally. Before looking at the third proviso in the context of the deed in which it appears, or the deeds in which it appears, I want to address what the judge seems from the heading above paragraph 39 of his judgment to have regarded as the natural meaning of the word interests in isolation. However, I want to preface my submissions by making clear that in our submission, it's actually rather an unhelpful exercise to ask what interest means in isolation. As Lord Justice Ucci said at paragraph 77 of Britvic, language is never used acontextually. The meaning of every word in a provision is influenced by the words that surround it, and indeed influenced by the provisions that surround the provision in which it appears. So even if one does consider the meaning of interest in isolation and divorced from context, it can only be the start, not the end of the inquiry as to what is meant, what it means in the context in which it is actually deployed. Now, that said, in my submission, even if one looks at the meaning of the word interest in isolation, it can readily be seen that, contrary to what the judge seems to have concluded, it has no single or natural meaning. And that fact is amply demonstrated simply by the pages and pages of different dictionary definitions contained in the authorities bundle, showing all the different meanings which the word interest is capable of bearing, depending on the context in which it is deployed. Indeed, it's precisely because the word interest is capable of bearing more than one natural meaning that its meaning in the third proviso can only be resolved by looking at the word in the context in which it appears and the commercial purpose of the legal arrangement, the pension scheme, in which it was included. Now, obviously, in the light of the various dictionary definitions, the BBC would accept that in certain contexts, the meaning of the word interest is capable of meaning more than legal rights, more than simply legal rights. Equally, we say, it is salutary to note that the primary Oxford English Dictionary definition, which your lordships can see and ladyship can see at tab 54 of Authorities Bundle 3, that primary definition does equate the word interest with a legal right or claim to or on property. That's the very first meaning. Now, whether, of course, in my submission, that's significant, because in relation to what was said in Bernardo's and Safeway about the importance of the language being used, we defy anyone to argue that the primary OED definition of the word interest represents a strained construction of that word or a departure from its plain meaning. Whether, of course, the word interest bears that particular meaning must be determined by considering the overall context in which it is used. But in my submission, what is clear that if the context does suggest that the interests of members which are to be certified by the actuary was intended to be a reference to their legal interests under the scheme, as defined by the BBC, adopting that construction would not be straining the language used. Now, for his part, the judge considered that the meaning of interest in isolation had a much wider natural meaning than the BBC suggested meaning. The judge considered that the natural meaning of interest read in isolation meant effectively any matter of relevant concern to the position of a member. For their part, those representing the representative beneficiaries suggest paragraphs 30.3 of their skeleton that the word interest extends to mean the object of any human desire. That's taken from Black's Law Dictionary. They also rely on the case of Hill and Spread Trustee, which is at tab 10 of Authorities Bundle 1, in support of the case that a wider meaning should be given to the word interest in the third proviso. I'm not going to spend time going to that case. It wasn't relied on by the judge, and in my submission it doesn't take the representative beneficiary anywhere. In particular, there was no attempt in that case to define a general meaning of the word interest. It was solely concerned with the meaning of interest in the particular context of section 423 of the Insolvency Act 1986, a provision which, for good measure, Lady Justice Arden had described at the beginning of paragraph 101 of the judgment as having a, quote, unusual scheme or structure. The representative beneficiary further suggests at paragraph 32 of her skeleton that the drafter's use of the word interest was, I quote, deliberately simple and broad. But with respect, the draftsman's use of the word interest was neither simple nor broad. The draftsman did not deploy the word interest in isolation, like a dictionary. He deployed the word in a specific context, and that context must be factored in before deciding what the word means. And in my submission, once one starts to factor in the context, whether be the context of the 1949 deed or the current deed, it doesn't matter. It becomes clear that the word interest cannot have been intended to bear the wide meaning attributed to it by the judge and the representative beneficiary. Now, the first point to make is that on the judge's formulation, the meaning of interests in the context of an occupational pension scheme, and specifically in the context of a proviso to a power of amendment, would cover an incredibly wide range of matters. If the judge were correct, the third proviso would not only preclude amendments to future service benefits, it would catch a wide range of amendments that the trustee and employees might think of making. So on the basis that the third proviso is engaged whenever an amendment affects any matter of relevant concern to a member, an active member is no doubt relevantly concerned by matters which affect the security of his benefits under the scheme, both for the past and future. He or she may well be concerned with the good administration of the scheme and therefore the powers of the trustee or the composition of the trustee board. An active member might also be concerned with changes to the scheme's admission policy for new members or with the rate of accrual for benefits for other members, given that both those matters could affect the security of his or her own benefits. Now, in my years of experience dealing with occupational pension schemes, I have never seen a restriction on a power of amendment with that scope, and I venture to suggest that neither have my learned friends. Indeed, what would be the scope and purpose of the power of amendment in those circumstances?
Mr. Tennant, we don't have to come up with a general definition of interests, do we? We only need to answer the specific questions that were posed. And if the judge's overall elaboration of the meaning in his phrase matters of relevant concern is too broad, which it may be, that doesn't necessarily lead to the answer that you want in relation to the questions that are being posed by the claim form.
Not necessarily, but as I say, it is an indication that the answers we propose are the correct ones. But I agree, it does not follow automatically. But the first point, obviously, I need to address is the way our case was dealt with below, and the way it was dealt with below was to give interest a wide meaning, and that's a meaning which, in my submission, it can't bear. And I am going to address the point which your lordship has just made now, because no doubt aware of the difficulties with the judge's formulation, those representing the beneficiary attempt to circumvent them when they suggest that whatever else interests means active members have what they describe as a central interest in continuing to accrue benefits in the scheme on the same basis as currently. And that reference to a central interest is an implicit recognition that on the judge's construction of the word interest, the word clearly has a meaning beyond that central meaning. And the problem for the representative beneficiary in my submission is that it's difficult to explain as a matter of language why the meaning of interest extends to the members concerned to earn future service benefits, but does not extend to an active member's other legitimate concerns, for example, in relation to the security of benefits or the good administration of the scheme which they're relying on to provide their benefits. I mean, at the end of the day, the trustees are no doubt hoping for a decision of this court which will enable them to decide with clarity in future what is and is not being caught by this proviso. And therefore they do need something a little further than simply a decision on specific matters in terms of the rationale for that decision as guidance. And of course, if you're going to come to a specific decision, the rationale for that decision has to stand up to scrutiny in my submission in other respects. Once you depart from the meaning of interests as connoting legal rights and entitlements, which it's clearly capable of meaning, in my submission it's hard to find a logical stopping off point because there's no easy way of differentiating between different legal, non-legal interests, i.e. interests that don't amount to a legal entitlement to benefits at the date of an amendment. And the other point to make about the judge's view of the natural meaning of interest is obviously it is actually deployed, not in isolation, but in the context of a description of a process where the impact of an amendment on the interests of members is to be the subject of a process of actuarial certification. And in my submission, that implies that the impact of an amendment on the interests of individual members will lend itself to an actuarial assessment and certification. And actuaries do not typically value benefits that could potentially accrue to an individual member as a result of future service, because there's no way of assessing what the value of those benefits will eventually be to that individual member. It will obviously depend, for example, on how long the members are proposing or do remain in service. If, for example, after the establishment of this scheme, it was proposed to amend it so as to reduce the basis of, or the rate of future accrual, but to allow members to qualify for a contingent pension after 2 years than 5 or 10 years, so in other words, that's the point at which the contingent right kicked in, the actuary would have no way of assessing which was more valuable to the member without knowing how long they intended to remain in service. And that's the difficulty of valuing potential rights rather than rights.
Is the, you're going to take us to it, but does that element of the proviso look at matters individually, or is it active members generally?
I believe it's the rights of any member. So it doesn't use the word injured, but it says it takes effect as regards of the active members whose interests are certified by the actuary to be affected. So the actuary would have to look at the position of each active member to decide whether his or her interests were certified. And if it didn't, if he certified that, it would not take effect as regards that active member.
That seems a very large burden to place on the actuary if he's got to consider each active member individually rather than as active members as a class.
In my submission, that doesn't necessarily follow, my lord. I see the point, but the most active members will, in relation to their past service rights, have a homogeneous set of benefits. So when you look, and this is partly the point. When you look at the past service rights of active members of the scheme, you will expect them to be broadly the same. When you look at the potential for further rights, the position is not the same, and the burden does become different. And although I take Justice Lewison's point about the full extent of the judge's decision on the meaning of interests, on that view, just to be absolutely clear, there are no end of other amendments which could impact on the member in a way that would also not be capable of an accurate actuarial certification. So an actuary...
But is that what's involved? He doesn't have to come up with a value, does he? He just simply has to know whether it's above the line or below. Does it prejudice their interests or does it not?
That would not necessarily involve assessing a value in all cases. In certain cases it would. But the point I'm making is, to put it in a practical context, is how would the actuary certify the actuarial impact of a new admissions policy on the security of an individual member's benefits, or indeed all members' benefits, for that matter. I mean, to give another non-hypothetical example, take the recent amendments to the procedure for holding meetings of active members, which make new provisions for hybrid and virtual meetings. And those changes are set out in the amending deed at tab 9 of the supplemental bundle. On the judge's analysis, if one goes the whole way, those amendments do affect the member's interests because the procedures for voting through prejudicial amendments are themselves matters of relevant concern to an active member because they potentially affect his or her ability to cast his vote or the validity of resolutions passed at such meetings. So potentially, on the judge's analysis, those amendments do affect the member's interests and engage proviso 3. Yet plainly the actuary would not have any relevant skills or qualifications to enable him to make an assessment of whether there was an impact on members as a result of that deed. Now, the representative beneficiary accepts paragraph 50 of her skeleton that the process of actuarial certification of interests required by proviso 3 may not involve the exercise of actuarial expertise, but they argue that for simplicity's sake, it nevertheless made sense for the actuary to make all assessments of whether an amendment should be precluded, whether or not that involved an exercise of professional expertise. In my submission, it doesn't make any sense at all to entrust to a person whose only qualification for the role is actuarial expertise the responsibility for making non-actuarial value judgments as to whether an amendment should be allowed. Deciding whether that type of amendment should take effect should be the role of the trustee or the employer, and on this hypothesis, they will have already both decided that the amendment should be made.
Just before we go on, just going back to your premise of matters of relevant concern and some of your examples, for example, voting, just looking at the wording of the exceptions, I'm taking it just from page 24 of your skeleton argument, page 24 of the core bundle. The second exception might inform the meaning of interest because it's talking about, to the extent the interests of such members are so prejudiced, substantially equivalent benefits are provided. That might suggest tying the concept of interest to prospective benefits.
Well, it certainly suggests that tying the concept of interest to equivalent benefits, but it is entirely neutral in my submission as to whether those are past service benefits, i.e. the rights or...
No, I'm making a slightly different point. You're saying, well, the concept of interest could extend to how you vote, for example, or the admissions policy in relation to prospective new members. I'm saying that one possible interpretation, reading the words in context, as you say, should be done, you get some indication of maybe what the draftsman is getting at through that exception.
Indeed, and I am obviously advocating for a
Now, well,
concession.
it doesn't mean that you're.
Yes,
it
no, I'm
doesn't
not-
necessarily
obviously-
follow from that your interpretation is right.
And
I'm
I
making a different
I
point.
completely accept that. It's the same point with respect as made by Lord Justice Lewis. It doesn't get me home. What it does suggest is that something's gone wrong with the judge's wide interpretation of interest, and in the context, it can't actually bear that meaning. Now, obviously, what I say the context does is indicate that the interests have to be the matter of an actuarial certification, and that, in my submission, in the light of the difficulty of valuing potential rights rather than rights, what the draftsman is actually getting at is past service rights, which actually the member already has, not just what he may or may not get in future. And therefore I rely on the role of the actuary for that purpose. And we say that is consistent with the way in which the third proviso envisages that substantial prejudice will be determined not just by an actuary, but by a process of actuarial certification. But I'm not saying any of this gets me home at this stage. I'm simply saying it's a clear. Essentially, it just backs up my submission that you can't draw firm conclusions to the meaning of the word interest in isolation because it's not used in isolation. Even if you do consider the meaning of the word interest in isolation, the meaning contended for by the BBC corresponds with the primary OED definition of that word. And the moment you start considering the meaning of interest in the particular context of the third proviso, in my submission it becomes obvious that interest cannot bear the natural meaning suggested by the judge in any of the places in which it appears. But obviously, in my submission, there is more support for the BBC's construction of the third proviso in the way the word interest is used elsewhere in the other provisions of the 1949 deed and in the current deed and rules. And it is those deeds to which I would now turn.
Just before we leave exception B to proviso 3, your argument, as I understand it, is that the trustee, with the consent of the BBC, may take away rights which the employee has already earned by past pensionable service, provided that substantially equivalent benefits are provided or paid for by the BBC or provided under any legislation.
Yes.
So we're talking about the removal of past rights with a substitute. What kind of legislation would operate retrospectively to give equivalent benefits to a member who's already earned the right to benefits by past pensionable service? My first question. And my second question is, following on from Bradbury, it was accepted in Bradbury that once the BBC had decided that X pounds counted as basic salary, it couldn't go back on that decision. But your argument, I think, says, well, it could, provided that it did something equivalent. Have I got that right?
Well, it is always open, it would be open to the BBC under this provision and the trustee to set up a mirror scheme, for example, into which members were transferred. For example, if there was some joint venture between the BBC and another entity and they had a pension scheme, yes, you could transfer the members and their past or amend so the rights in this scheme ceased and they got exactly the same rights in the other scheme. As for legislation, with respect, can I go away and have a think about that? But it's possible that they were contemplating, the setting up of a new social security system, and this is just after the Second World War, where individuals became entitled to state benefits at 65, and there was contemplation that the state pension scheme would in future extend to be more generous perhaps than it ultimately became. But, I mean, that is of course just speculation. But the short answer is that obviously I say that substantially equivalent benefits in B are substantially equivalent past service benefits. With that, can I go to the context of the 1949 deed and the present deed? So this is in supplemental bundle, and we'll pick it up with the interim deed at tab 1. Just by way of background, this was the deed that actually established the scheme from the 23rd of September 1947. And because of the time it took to get exempt approved status from the Inland Revenue, it was commonplace to have a short interim deed of this nature, just establishing the scheme with some basic ground rules, and then to supply the more detailed terms in a definitive deed, which was then expressed to take effect from the date of the interim deed, but was actually produced sometime later. The interim deed and the definitive deed in this case were intended to operate together, and no doubt for this reason, as we shall see, clause 2 of the definitive deed and rules subsequently provided that that deed should be read and construed as if it had been executed on the same date and immediately after this deed. So if we could look at clause 4 of this interim deed, this provides that the said definitive deed shall provide that save as hereinafter provided, no amendment, no payment shall be made to the corporation of any part of the funds or benefits of the fund, provided always that the said definitive deed may provide for the payment to the corporation on the winding up of the fund of any surplus assets of the fund which shall not be required for A, the purchase of annuities for the remainder of their lives for those of the members of the fund who are in receipt of or entitled to pensions, that's obviously pensioners, and then going down to B, the purchase of such annuities or the making of such lump sum such lump sum payments to the members of the fund as shall correspond with their respective interests therein. And in my submission, subparagraph A is providing for the securing of pensioners' interests by the purchase of annuities, and subparagraph D is therefore dealing with the active members of the fund, and the need before paying surplus to the BBC to secure by the purchase of annuities what the draftsman chose to describe as the interest of such members on a future winding up. Now, all occupational pension schemes provide for the winding up of the scheme by the purchase of annuities using the assets of the scheme, and that process is colloquially known as a buyout of members' rights. And subparagraph B mandates that annuities that will be purchased will correspond to the interests of active members in that situation. And obviously what is brought out by the purchase of annuity on a winding up of the pension scheme, what is replicated by that annuity are the existing rights of pensioners and active members to pensions or prospective pensions earned by past service as at that date. Obviously, schemes do not buy out or secure future service rights on a winding up, because past service benefits are all that active members are entitled to at that point, and there will be no future service after the winding up. And the BBC's entitlement to surplus on winding up was therefore a right to the assets after the members' past service rights had been secured. And obviously the key point for present purposes is that the draftsman of the interim deed chose to describe those past service entitlements of active members as the interests of such members in the fund. Now, it will also be noted that at page 2 of the same deed, clause 7, no amendment could be made to the scheme which would allow to be returned to the BBC the surplus unless that was in accordance with clause 4, which we've just looked at after AIG, after annuities have been purchased securing the interests of members. And that is why the restriction in clause 4 of the interim deed on the payment of surplus to the employer found its way into the second proviso to the power of amendment in the current deed. If then turns to the definitive deed, which is at the next tab of this bundle, you'll see on page 5, sorry, the first page, dated the 23rd of June 1949, so that's some 2 years later after the interim deed. That's actually quite prompt for the production of a definitive deed. And this document then sets out the definitive basis on which the scheme is to be treated as having been established from 1947 and the terms on which it will be governed by from that date. And the court will see, if you look at clause 2 of the definitive deed and rules on page 7, that the deed should be read and construed and take effect in all respects as if it were dated and had been executed on the same date and immediately after the interim deed. So the two are to be construed together. As regards the operative provisions of the definitive deed, I want to look at we'll start by looking at what we described in our skeleton as the protection provisions. And we so named them because they're all provisions which have the same basic function. They're all there in our submission to protect and preserve an actuarial assessed bundle of rights attributable to members and pensioners under the scheme. And those protection provisions comprise, in addition to the third proviso itself, the second and fourth provisos to the power of amendment and the winding up provisions of the scheme. And what is striking, and in my submission was not a coincidence, is that in all these provisions, including the third proviso, the draftsman chose to protect exactly the same thing, namely what he chose to describe as the member's interests. Further, expressly or by implication in each case, the extent of those interests was to be determined by an actuarial assessment by the scheme actuary. So I want to start by looking at the second and fourth provisos to the power of amendment in the 49 deed. The power of amendment is at clause 25 of the deed, which is at page 14. It's vested in the trustees, but requires the consent of the BBC to its exercise. It has 4 provisos, A to D, restricting its use.
Sorry, can you give me 14?
I'm so sorry. It's page 14 and clause 25.
Oh.
Yeah, there's a whole set of clauses and then a whole set of rules. And this is the clause. So it has 4 provisos, A to D, restricting its use, and these are now referred to as the first to fourth provisos. The first proviso, A, is not relevant for present purposes, simply provides that the power of amendment can't be used to change the purposes of the fund. The second proviso, at B, is relevant. It provides that no amendment shall be made that will allow funds to be paid to the BBC, save as permitted by clause 4 of the interim deed. So in other words, this is the proviso giving effect to the terms of the interim deed we've already looked at. It thus deploys the concept of members' interests within the power of amendment in a way that is intended to refer to the past service rights of members. And if you turn to our skeleton, just have this side by side at this point, paragraph 11, you can see the markup we have prepared. It's at core, page 25 of the core bundle at tab 2. you can see from the markup that in the current deed, the second proviso, instead of currently simply cross-referencing clause 4, writes it out longhand. That change was no doubt done for reasons of convenience and changed the outward appearance of the second proviso, but it did not in any way change its substance or meaning. It just meant that the reference to members' interests being secured by the purchase of annuities actually appears in the second proviso as well. And although proviso 2 does not itself refer to the actuary's role in the process, as we shall see in the winding up provisions to which proviso 2 does refer, it does fall to the actuary to determine what annuities correspond to the value of the active member's interests, and that by that clause means past service interest. So passing over for the moment the third proviso itself, it can also be seen that the fourth proviso adopts the language of interests being affected when seeking to protect the interests of non-active members, namely those in receipt of a pension or contingently entitled to a pension on the death of a pensioner. So, for example, dependents from prejudicial amendments. And in my submission again, it's clear that the reference to interests in the fourth proviso is a reference to the legal rights of pensioners to future payment of a pension which has already been earned by the pensioner's past service prior to retirement. So in this context too, interests in the proviso clearly does not have, or the power of amendment does not have the meaning which the representative beneficiary asserts as its ordinary and natural meaning, namely something that's wider than existing legal rights. Plainly, the word is not being used to refer to the potential for future accrual of rights, and the role of the actuary in relation to the fourth proviso is clearly envisaging an actuarial certification of rights rather than potential rights. And proviso 4 too, you'll see from our skeleton page 25, remains in essentially the same form as it was in 1949, with only very minor definitional changes. I then turn to the winding up provisions in the definitive deed, which are at Rule 22. And those are page 31, 32 of the same tab. So halfway down, the court will see that the corporation, which is the BBC, has a power to trigger a winding up by serving notice, which terminates its liability to pay contributions. And it provides that whereupon the contribution of members shall also cease, 5 and 6 lines down. As I shall be explaining, the exercise of the BBC's power to terminate contributions would also have brought future accrual to an end, and I shall be submitting that too is also relevant to the scope of proviso 3. But just pausing on as the effect of the winding up provisions themselves, once the liability to contribute has terminated, Rule 22 provides that the scheme may, unless the trustee chooses to run it on as a frozen scheme, be wound up. And picking it up at the words "in the event of such termination," the winding up then involves various stages. Firstly, the investments of the fund are to be realised, and after the payment of costs, proceeds are to be applied in the following order of priorities. And the first order of priority is the purchase of non-commutable annuities in the same amount and duration as pensions payable to persons in receipt of pensions, i.e. pensioners and their dependents. The annuity therefore will replicate the members' existing pensions based on past service. And second, in relation to what we say are active members, in the purchase of annuities, immediate or deferred, for members entitled in anticipation to pensions or other benefits under the pension scheme, that's effectively a contingent right. Each such annuity to be of such yearly amount and on such terms as shall be determined by the actuary to be just and equitable, having regard to the value to be determined by the actuary of their respective interests in the fund. And thirdly, after those provisions have been made, there is a provision for payment of the balance or the surplus to go to the BBC, and that is consistent with the circumstance contemplated by the interim deed, in which sums could be repaid to the employer. And in my submission, the second part of this rule is clearly dealing with active members who for the most part would not have reached NRD, and it's clear that the contingent rights which would be secured on a winding up are the past service benefits of and attributable to those active members up to the date of winding up, and not, because the scheme is coming to an end, any future service rights. And again, it's the rights to those benefits which the draftsman chooses to describe as the member's interests. And again, it's the value or the extent of those interests which falls to be determined by an actuarial assessment. And that's to be determined having regard to the value of the interests in the fund of those active members. Now, for the reasons already explained, that is clearly, in our submission, that is clearly a reference to the actuary exercising his professional judgment as to the value to be attributed to the member's past service rights. But the representative beneficiary takes 2 points in relation to Rule 22, which is probably convenient to deal with at this stage. First, they argue that the actuary was not simply asked to value and buy out past service rights, he was instead being given a wide discretion to augment and reduce members' past service rights as he saw fit. And secondly, and in my submission slightly inconsistently, it suggested that Rule 22, the reference in Rule 22 refers to the members' interests in the fund, and that is not the same concept as the members' interests in the power of amendment. So far as the second point is concerned, in my submission, the words in the fund in Rule 22 do not change anything. Proviso 2 to the power of amendment, which again we recite at paragraph 11 of our skeleton, also speaks to the need for the trustees, perhaps we can have that up, paragraph 11 on page 25 of the core bundle. That also speaks of the need for the trustees to secure for the members of the fund, meaning the active members, annuities that correspond with their interest therein. An interest therein would also appear to mean the interests of such members in the fund. And in my submission, it can't plausibly be suggested that when in the very next proviso, the draftsman refers again to the interests of members, by which he again means members of the fund, he is attempting to describe an entirely different type of interest. And for good measure, the words in the fund also do not appear after the word interest in the fourth proviso, yet no one could doubt that the rights of pensioners to pensions in payment do constitute an interest in the fund. So in my submission, the draftsman was clearly not intending to signify anything different by not adding those words each and every time he referred to interests. The second submission is that the actuary has a wide discretion to decide who gets what on a winding up. That was not accepted by the judge, and in my submission is impossible to square with the language used, the natural role of an actuary or the BBC's entitlements to surplus after the members' benefits have been secured in this way. In my submission, had a wider discretion been intended, different language would have been used, and the discretion would have been given to the trustee, not to an actuary who would have been wholly unqualified for that role. And it's instructive to look in this respect at what the Court of Appeal said about the proper role of an actuary in the recent case of Railways Pension Trustee Atos, which we referred to at paragraph 13 of our supplemental skeleton. That case is at Authorities Bundle 3, tab 3, sorry, authority under 3, tab 35. You'll see well, one of the issues in this case was, and you can pick this up from the italicised heading just above paragraph 60 on page 1031, was whether the use of the words determined and determined conferred a discretion on the actuary in relation to the increase of contributions and the reduction of future benefits. And at paragraph 68, the Court of Appeal answered that question by stating that the requirement in the rules of the scheme for the actuary to determine the increases to contributions connoted an exercise of professional judgment to be exercised in the light of the detailed knowledge the actuary would have about the scheme, having applied all relevant actuarial assumptions and subject to all professional guidance. And that's the first half of paragraph 68. And further at paragraph 73 to 75 on page 1034, the Court of Appeal went out of its way to explain that it was not accurate to describe the description of the choices to be made by the actuary as an exercise of discretion, like a trustee or fiduciary. The actuary was instead required to exercise his professional judgment about matters within his expertise, namely the contributions needed to fund the scheme on the basis proposed by the trustees. And they specifically said, when performing these functions, this is the last bit of paragraph 75, the actuary exercises professional skill and judgment. Describe the making of choices inherent in such a process as the exercise of discretion is misleading and liable to confuse. Accordingly, in this context, the language of discretion is better avoided. So that would, the role suggested by the representative beneficiary for the actuary would not be a normal or usual role for a professional expert like an actuary. And overall, the idea that the actuary is being entrusted with a power to alter what members had already earned by past service by giving certain members in his discretion more and certain members less is really a non-starter. If nothing else, the reason it can't have been intended is that the sums used to secure members' benefits also define the residual entitlement of the BBC to surplus, and the amount of surplus to be returned to the employer cannot have been intended to be in the discretion of the actuary. So, against that background, I return to the third proviso to the power of amendment at page 14 of the tab 2 of the supplemental bundle. Again, as regards the third proviso, as is made clear by the comparison we produce at paragraph 11 of our skeleton, it remains essentially in the same form as in the current deed, the only intervening change having been to introduce an express definition of the term active member to whom the proviso applies. And the third proviso states that no amendment shall take effect as regards active members whose interests are certified by the actuary to be affected thereby, unless the actuary also certifies that the prejudice is not substantial, substantially equivalent benefits are all provided, or the active members in question also approve the amendment at a meeting convened by the trustees. And in my submission, the draftsman's deployment of the same concept of interest of members and the requirement that they be subject to an actuarial assessment is a clear indication that the third proviso is dealing with the same concept of past service rights as the winding up provisions and the third and fourth provisos to the power of amendment which surround this. Now, obviously, there are a number of points taken by the representative beneficiaries in response to this, to which I'll now turn. The judge saw no inconsistency between the meaning of what we have termed the protection provisions, because he regarded the expression members' interests as necessarily conform to what he described as the position of each member protected. And the representative beneficiary takes the same line, relying on what is described as the inherent pliability of the term interests. On the judge's view, for example, pensioner interests were necessarily limited to past service benefits because they can't accrue future service benefits. But in my submission, it is inimical to a process of construction to attempt to ascertain what a word means in isolation, and then, when the context demonstrates that it does not actually bear that meaning, to seek to avoid that conclusion by arguing that the context must therefore be treated as changing the meaning only at that point and only to the extent necessitated by the context. In my submission, where there is a range of dictionary definitions available, the process of construction should be approached without preconception as to what meaning within that range the word bears in a particular context, in the particular context of the provision which the court is being asked to construe. And what we know is...
Mr. Tanner, forgive me for being slow. I quite understand the submissions you make, that the word interest or interest in the members needs to be read in context, and that's the context of the deal as a whole. What I'm not quite clear about at the moment is what added value to those arguments are you getting from looking at the 1949 deed, given that the same power with minor amendments is already to be found in the current version of the scheme with its own context, which doesn't, so far as I can see from what you've shown me, differ materially from the context of the 1949 deed. So what added value are you getting from the 1949
well,
deed?
the one provision which has changed is the winding up provision, because the winding up provision has now been changed to reflect the statutory order of priorities in the 1995 Pensions Act, Section 73. So for that reason, it doesn't follow the same. So there is something to be gained. But essentially, when I address the 1949 deed context, I am also addressing the context of the current deed for the same reasons. I don't want there to be any doubt about that, so I'm obliged for that an opportunity to clarify my position. All the points I'm making in relation to the 49 deed run equally in relation to the current deed. And I will specifically address the differences between them shortly in my submissions, but they are not substantial. So I am intending also to address the context of the present deed when I talk about the 1949 deed. So just to go back, the submission is that the court should start the process without any preconceptions about what interest means within the range of permissible dictionary definitions and construe it in the context in which it appears. And the idea that it can just be conformed of necessity to take a meaning different in each provision is, I think, difficult to square with the way the deeds are drafted. What we know is that in this case, the draftsman of the 49 deed and the current deed deliberately chose the same word interest to describe what was protected in three adjacent subclauses, the second, third and fourth proviso to the power of amendment, and they envisaged that the value of such interest in each context would be determined by the actuary. And the judge's approach of pliability and conforming doesn't address the obvious question of why the draftsman would have chosen the same word interest to describe the scope of the protection he intended to be conferred if his intention had been to describe and protect things which were of a very different nature. If, on the judge's hypothesis, the word interest has a natural meaning that is wider than is necessary to cover the intended degree of protection under, say, proviso 4 or the winding up provisions, in my submission, a competent draftsman does not just use that word anyway and rely on the context to force the reader to the conclusion that the word doesn't bear its natural meaning. He chooses a different word.
Sorry, just to be clear, are you effectively saying that he would have chosen a different word in, say, the fourth proviso, such as rights?
No, well, I'm suggesting he chose the word interests in the fourth proviso to refer to past service rights. Had he intended...
But
the third...
pausing there, it is obvious. I mean, the argument against you is that those other in the context of those other provisos, the interest can only relate to past service. So
well,
why does it follow from that it has?
Well, because if he'd intended to, if he thought that past service rights were if he believed that interest was very wide, in my submission, he would have chosen a different word to describe the rights of pensioners. Yes, or he certainly wouldn't have allowed the same provision, the same word, to appear in successive clauses and in the winding up provisions to describe different things. He wouldn't have relied on context to force the reader to the conclusion that they had a different meaning.
Can I have another go? I think you may be saying, or I'm understanding you as saying, that for the representative beneficiary to be right, the draftsman would have used, for example, the words accrued rights or something of that nature in the other provisos to allow interest to have a broader meaning in the third proviso.
Yeah, or made it clear that interest included the potential to earn further rights in the third proviso, rather than just past service rights, which is what that word signified when it was used in the very next proviso and indeed the preceding proviso. So the protection provision is not the only other provisions of the scheme which, in our submission, demonstrate that the word interest does not bear the meaning found by the judge. In my submission, the existence of a power to terminate future accrual without member consent in both the 1949 deed and the current deed is the strongest possible contextual indication that the judge's view as to the meaning of interest to be certified by the actuary is incorrect, and that it does not protect the right to future service benefits. The judge did not refer to or address this power of termination in his judgment. I will look at it both in the 49 deed, because it's open, and also in the current deed, but the submissions are similar effect. In the 1949 deed, the power to terminate accrual was contained in Rule 22 of that deed, which is on page 31. And as we've already seen, those opening words enable the BBC to trigger a winding up by serving a notice terminating its liability to pay contributions. And that goes on to provide, thereupon the contributions of members under Rule 3 shall also cease. And the significance of that, if you go to Rule 1 and the definitions, which is at page 17, one can see that the definition of contributory service, i.e. service that qualifies a member for benefits, pensionable service in modern day parlance, is dependent on the continuing payment of contributions by the member. Contributory service means service during which a member contributes to the fund under Rule 3. So service by the BBC of a notice ending both it and the members' contributions would bring both further contributory service and the accrual of pensions to an end. And the BBC's position is that it would be astonishing if the draftsman of the 1949 deed had sought to ensure that future accrual was protected from even quite modest amendments under a bilateral power of amendment which required the trustees' consent, yet at the same time and in the same document he happily conferred a unilateral power on the BBC which allowed it to terminate future accrual completely. And there's simply no coherent explanation in my submission of why the draftsman would have chosen to give the BBC an untrammelled power to terminate accrual completely, but not allowed it, via a bilateral power with the trustee, simply to amend the rate of future accrual by reducing it to an affordable level. Now, the representative beneficiary argues, paragraph 69 of her skeleton, that the right to terminate accrual and wind up provided the BBC with an alternative way to control costs. But in my submission, no competent draftsman would have regarded a power to terminate the scheme completely as an appropriate way to control future increases in cost compared to an amendment of the scheme. If the BBC really merely wanted to control costs, for example, by shaving something off the future rate of accrual or increasing member contributions, on the representative beneficiaries case, it would have to close the whole scheme down. That would be, in my submission, a wholly impractical and eye-wateringly expensive way of proceeding.
Sorry, when you say expensive, as I understand it, it wouldn't have been so expensive in 1949, is that right? I mean, these days, as I understand it, if you do that...
Well, I think at the time it would start... I mean, but basically, it requires the BBC, then, to make alternative provision for existing pensions.
Yes, for existing pensioners.
Yeah.
And for past service. How expensive that is or not depends on the current state of the fund, doesn't it?
Well,
annuity rates at the time and so on.
It is, but it is generally more expensive to secure the purchase of past service benefits through annuities than it is to do it through your own fund, because obviously the purchase of annuities from a third party and involves a profit element to provide the same benefits. So that is why you have provisions in pension schemes that allow pensions to be paid by the fund rather than simply buying annuities at the end of the member's service.
This may not be relevant. Clause 22, as I read it, and I may well have missed something, doesn't require the BBC to fund a short. The annuities are just bought out of what is in the fund, and if there is a surplus, it goes back to the corporation. I understand that since then there's been a whole set of legislation which can impose very onerous obligations on employers.
But that of course is right. But of course, if the fund was just above funding on if it was provided by the scheme and annuities were more expensive, that would produce a deficit and may require. The point is, even if the BBC was required to fund it or not required to fund it, it potentially costs more money to secure annuities outside the scheme than it does through the scheme. And it's obviously, there's also the whole process and expenses of buyout to be gone through. It's clearly not a convenient thing to do in my submission. And that's just the pensioners. For the actives, the BBC would then have to start a completely new pension scheme simply because it wanted a slightly reduced accrual rate, which in my submission also would not be a straightforward or quick process. And your Lordship and Ladyship have already seen it took 2 years from 1947 to 1949 simply to get Inland Revenue approval for the present scheme. I mean, that is a reflection of the complexities of the process which it takes to establish these schemes. So this really was not a sensible way of controlling costs. And the draftsman's, I mean, quite apart from whether it was or wasn't, it does not make sense in my submission for the draftsman to confer a separate power to terminate future accrual completely, but not to let the trustee and the employer only modify it. I mean, the greater surely includes the whole. There can't be any reason for giving them a greater power, but not the later power. It makes no sense at all. So it's a very strong indication that future service rights were not being protected by the power of amendment. As for the current deed, if we can just look at this, that contains a similar power to terminate accrual. It's the composite version of the deed is a supplemental bundle divided 10 at page 217. Right, 214. This is the modern day version of the power, but it's the similar effect. That provides the scheme will be frozen if the BBC gives...
Sorry, just before we get there, I noticed that the text at the start of this document, page 106, describes this as a working copy.
Yes.
So it's someone's mechanical, let's put all the variations in, rather than this document is itself an executed deed.
Exactly right. I mean, I will come to it, but if your ladyship wants an example of an executed deed, you can find it in the tab 7. That's what the deeds of variation actually look like.
Thank you.
And you'll see that describes it as supplemental to the 1949 deed.
Thank you. So, which
Maybe
page?
if one of the friends forgive me for making another hopefully helpful observation, if you look at page 106, you can actually see from what the working copy is taken, which refers to the last substantive deed containing consolidated amendments, which is the 2016 deed, the 52nd deed, and also then takes account on top of that of various 2 other deeds of variation and work them into the same document. So it from
I'm not sure whether. I don't suppose we can do anything about this. Can he not turn off the yeah, no, okay.
Hello, sir. I'm just wondering if you could mute your mic while you're not speaking, just to ensure that it doesn't disturb the hearing, because the background noise is slightly loud in the courtroom. Is that okay?
Yeah, okay, mute it.
Okay, thank you. If you would like to speak, just unmute yourself, and then we'll be able to hear you. Thank you.
Thank you, that seems better.
Thank you. What page should
Sorry,
we
it's
go to?
page 214. So that provides that the scheme will be frozen if the BBC gives written notice to the trustees terminating its liability to contribute to the scheme. And that 18.2, following the scheme becoming frozen under Rule 18.1, you get the, unless the trustees decide otherwise, either in individual cases or generally, any active member will be treated as leaving service at the freezing event, and no service after that will be pensionable service. So, although on the face of the current rule, the trustee must also consent to the termination of future pensionable service, in my submission that is an equally powerful contextual indication that the power of amendment does not protect future accrual, because if the trustee employer jointly have a power to bring future service to accrual to a complete end without member consent under this provision, in my submission it would be equally bizarre if the same parties could not also exercise their joint power of amendment under Rule 19, which is the very next provision, simply to modify that future accrual. It's probably convenient at this point to briefly deal with the other levers suggested by the representative beneficiary and trustee in which the BBC could control future costs. Suffice it to say, all the suggestions involve mechanisms outside the scheme that would necessitate the contractual agreement of members, non-pensionability agreements and changes of contract to non-pensionable employment. Those would provide the BBC with no more control than the current power of amendment on the judge's construction, as they would all be subject essentially to member agreement. It is also, with respect, a little unrealistic to consider that the draftsman in 1949 had non-pensionable salary agreements in mind as a method of cost control rather than the power of amendment, given that, as is recognised by footnote 5 to the trustees' skeleton, such agreements only really came to prominence following the South West Trades case in 1997, which was obviously some 50 years after the provision had originally been introduced. Just dealing with other differences between the 1949 deed and the current deed, there are two I'd like to draw attention to. In particular, Rule 10.6 of the current deed, which deals with benefits not being assignable. That provides, this is page 188 of the composite document already before the court, that an entitlement or prospective entitlement to a benefit under the scheme will be terminated if a beneficiary attempts to assign or charge it, an event occurs by which it becomes payable to some other person, or a bankruptcy order is made against the trustee. That's over the page on 189. And what's significant is that sub-rule 3 then says the termination of a beneficiary's interest under one above will not affect the entitlement to or the amount of any other pension payable on his death. And what is significant is that if one looks at what's described as the beneficiary's interest under 1, an entitlement to a benefit under 1 is obviously describing a legal entitlement to a pension in payment. And a prospective entitlement to a benefit, clearly in my submission, refers to a legal entitlement to a pension which will fall into payment on some future event, such as retirement. And the whole point about this is about the assignment of interests under the scheme. It's clearly talking about a right or prospective right to a benefit which has already arisen. And so interest in 10.6 is being used to define and describe exactly what the BBC says interest means in the context of Proviso 3 and Proviso 4, namely the legal entitlements of beneficiaries to present or contingent benefits. And in my submission, there's nothing in the representative beneficiary's point at paragraph 52 of her skeleton that clause 10.6 can be distinguished because it refers to a beneficiary's interest rather than a member's interest. members of the fund are clearly beneficiaries of the fund. Thus, in relation to a member, the phrase beneficiary's interest clearly means the interests of that member. Now,
does the concept of why is the concept of beneficiary used? Is it because it can cover relatives?
Because some schemes describe active members as members, and under a scheme you can have active members, which sometimes are called members. You can have pensioners who may be called members or beneficiaries, and then you have dependents who will be people who've never been members. They will derive their entitlement from the fact they happen to be the spouse or a child. So, but a beneficiary of a fund is apt to encompass active members, pensioners, and dependents.
Does it? I mean, in context, sub 4, seems to deal separately with spouses at least, and dependents. Might a beneficiary be used to cover the active, deferred, and members and pensioners?
Well, I accept it could do, but on any view it clearly includes members, which is obviously the point in relation to which I'm relying on it for.
Are you saying, I haven't fully followed what you're saying, under subparagraph 1 of 10.6, that's clearly talking about either accrued rights or a right which is contingent on a single future event like a retirement. Why could somebody not attempt to assign, because it covers attempts in A as well, why could somebody not attempt to assign their future pension rights in their totality?
Well, they could, but obviously there wouldn't be much point in doing that. In my submission, the word entitlement...
They might want to raise some money.
But I would have, in my submission, this is addressing the assignment of what members already have earned under the scheme, which is...
Well, that's the end point of where you want to get to.
Yes,
but what I'm struggling with is how you get there from...
Well, because of the use of the word entitlement. It's a prospective entitlement. And that is not apt for the mere potential to earn future benefits under the scheme.
I see, thank you.
Now, it's correct to note when comparing the 49 deed with the current deed that the winding up rule of the current deed has been rewritten in the current deed, and it doesn't any longer refer to interest. And you can see the current rule at pages 215 to 216 of this deed. And in my submission, nothing turns on that as far as the meaning of the third proviso is concerned. The reason that the form of the current winding up provision is not the same as the 49 deed is because the new winding up provisions here appear to have been amended to correlate with the compulsory statutory order of priorities on winding up, which was introduced by Section 73 of the 1995 Pensions Act. And although that's been amended since. And Section 73, which the new winding up provisions follows, adopts the language of entitlements and liabilities and pensions and benefits rather than interest. But that's clearly the explanation for why that has changed. So I turn now to the points made by the judge in favour of the word interests in the third proviso having a wider meaning than I have contended for. The first point we make in relation to that is that some of the judge's reasoning in deciding that the phrase interests of members to be certified by the actuary extended beyond rights to past service benefits was circular in that it was dependent on the correctness of his instinctive reaction as to the so-called natural meaning of the word interests. Thus, to take the example at paragraph 38 of our skeleton, having taken the view that the natural meaning of interest was very wide, encompassing matters of relevant concern, it was obviously easy for the judge to conclude that it was difficult to see on what basis it could be said that members' interest would not be affected by a reduction in future accrual rates. But that conclusion was, in my submission, simply a consequence of the very wide meaning he decided at the outset the word interest should bear. The learned judge's reasoning also seemed to us to be less than clear in relation to the nature of a member's ability to earn benefits by providing future service. So in this respect, we point out at paragraph 39 of our skeleton that in the last sentence of his judgment at paragraph 20, the judge appeared to accept that members had no promise that the employee would continue to accrue benefits from future service. So there was no legal right to future service benefits. But immediately prior to that, he had stated that the member has a promise that if certain things happen in future, then he will receive additional benefits as a result. Now, in my submission, it's not particularly, with respect, helpful to adopt the language of a promise that the member will receive benefits in future, even conditionally on future pensionable service, given the existence of the powers we have seen to terminate future accrual or amend the future accrual rate. To suggest that the member has any sort of promise of future accrual.
Sorry, on the second of those, not termination of future accrual, amendment of accrual rate, you could be accused of circularity.
Indeed, no, I completely accept that. That's on the BBC's case. But obviously that is not true in relation to the power to terminate. To suggest that the member has any sort of promise about future accrual is to assume against the BBC that the employer and trustee couldn't exercise the power of amendment or the power to terminate future accrual. Yet we have seen that there is a clear ability of the BBC and the trustee to terminate future accrual without member consent, and that's not in doubt, quite aside from the potential power to moderate, to reduce future accrual under the power of amendment. And similar criticisms can be made of the judge's suggestion at paragraph 45 of his judgment that the rules of the game under the scheme were that the members would continue to accrue the same benefits and that members had a present right to continue accrual. And again, those points seem to us to assume the very thing that is an issue. On the BBC's case, the rules of the game is that there's a power of amendment that can be used, unless precluded by the proviso, to change the rules to future accrual, and there's a power of termination under the rules of the game to stop future accrual. And the same points explain why we don't believe that you can say in any meaningful sense that members have a right or present right, which are phrases, or present latter being a phrase used by the judge, to future accrual. The fact that the BBC and the trustee have the power under this scheme at any time to prevent the members continuing to accrue benefits through the power to terminate accrual and, on the BBC's case, the power to amend the scheme, means that at the point of any amendment, members cannot be said to have a present right under the scheme to benefits from future accrual, nor do they even have the present right to continue to accrue benefits from future service. So there's no existing right, and there's no present right to force the BBC to allow continued accrual. Now, for its part, the representative beneficiary appeared to accept below that there was no legal right to the future accrual of benefits. And we cite in our skeleton argument, the transcript reference on which we rely at footnote 18, and that's at tab 2 of the core bundle on page 33. So the representative beneficiaries, for example, on day 2, page. Sorry, did I say that we're looking
You
at
said
the
core bundle, you're
Yes.
referring to the skeleton.
The skeleton,
Footnote
yes.
18, page
Yes.
33.
So the representative beneficiaries on day 2, page 1938 onwards, in the context of the 1949 deed of rules, they only had an interest in the rules of the scheme remaining the same. That's only an interest, it's not a right. So at that stage, there appeared to be an acceptance by the representative beneficiaries that the ability to accrue future service benefits was not a right. But on the appeal, there is an endorsement of the judge's suggestion at paragraph 47 of the judgment that the point of an amendment, the members can be said to have a present right in respect of future service accrual. And the representative beneficiary further argues that skeleton argument 35, paragraph 35, that future service benefits are themselves legal interests in the sense contended for by the BBC. Now, simply to put that point to bed, future service benefits are plainly not legal interests in the sense contended for by the BBC. The BBC's case, explained at the outset, is that a member's legal interest under the scheme, or member's interest under the scheme at any time, comprises the bundle of legally enforceable contingent rights to benefits from the scheme which he or she has already earned by past service. And the potential for future accrual is not that. Now, the representative beneficiary also, at paragraphs 36 to 37 of her skeleton, seeks to bolster the argument that members already have a legal interest in or a present right to future service accrual at the time of amendment because they're already in contributory service and will continue, they say, unless and until it's determined. And they say that contrasts the position on future salary increases, which, as the Court of Appeal pointed out in Bradbury, don't happen unless and until the BBC agrees to them. But in my submission, no meaningful substantive distinction can be drawn between future service benefits and future salary increases in this respect. Both future service benefits and future salary increases are still things that the member has the potential to earn in future, but has not yet earned. And although any increase in the member's pension benefits is indeed dependent on, as a result of salary increases, is dependent on the employer's willingness to agree a contractual variation of the member's employment contract conferring such an increase, the member is in no different position as regards or no better position as regards his or her ability to accrue further benefits through future pensionable service, because there exists on any view a right to terminate pensionable service under the scheme without member consent, quite apart from the potential right asserted by the BBC to do so as a result of the exercise of the power of amendment. Now, there is nothing in the point made at the beginning of paragraph 36 of the representative beneficiaries skeleton. The BBC's construction is treating the member as if he was not a member of the scheme at all. The member is plainly given the protection of the third proviso for all the benefits that he or she has earned as at the date of an amendment. And while it is true that the third proviso does not, on the BBC's construction, protect benefits the member has not yet earned, neither do 99.9% of powers of amendment, and yet no one complains that the members of those schemes, Wedgwood and Salt and Courage, were being treated as if they were not members of the schemes at all. It was simply accepted that the scope of the protection chosen by the draftsman did not extend to future service benefits. I turn now to another point which is relied on by the representative beneficiaries, which is the differences between the third and fourth provisos.
Sorry, just before you go on, can I clarify your in relation to past service benefits? You're saying they are protected by the scheme, and that you can look at the terms of the scheme. Effectively, you've banked or earned those rights. Any future service benefits are dependent on future employment, and I thought you were going to say that's separate and therefore doesn't count as part of the interest. In other words, you cannot. I thought you were going to say, but I don't think you have said, that you cannot take into account any assumption of future employment in determining what your benefits are. I think what you said instead is to rely more on the unilateral right to terminate accrual.
Yes, because that is a power under the scheme, yes. But what I say in terms of you can't say I have a right under this scheme to future pensionable service, because there is under this scheme a power to terminate it, and that's the point at which I'm quite apart, obviously, from the power of amendment. The differences between the third and fourth provisos are also relied on by the representative beneficiary in support of its case, and as has already been noted, under the third proviso, the interests of members can be overridden if the actuary certifies the changes are not substantially prejudicial, substantially equivalent benefits are provided, or the alterations approved at a meeting of the active members. Whereas under the fourth proviso, the interests protected, which are pensions already in payment, can only be detrimentally modified if the actuary certifies the changes are not substantially prejudicial, or the written consent of members of the pensioner is obtained. Now, in my submission, one reason that the second doesn't appear, substantially equivalent benefits are provided, is that there's no sense in which you need substantially equivalent pensions. You just have to provide the same pension, so that really wouldn't be relevant. The judge considered that these differences indicated that the pensions attributable to past service under the fourth proviso were, quote, benefits already earned and banked, i.e. the protection for pensioners was in respect of benefits already earned and banked, whereas the greater flexibility of the third proviso suggested that a different and broader type of interest was protected. And in our submission, that does not follow. On any view, if one accepts that active members have rights to benefits earned by past service, which they obviously do, the third proviso protects such rights to benefits. So thus, both the fourth proviso and the third proviso do protect benefits, which are, to paraphrase the judge, benefits already earned and banked. The difference between the protections given by the third and fourth proviso cannot therefore simply be that one protects past service rights and the others that do not. They both do. And in my submission, a more plausible explanation for the different levels of protection conferred by the third and fourth proviso is that the fourth is protecting the past service rights of pensioners and the third is protecting the past service rights of actives. And that explanation is consistent with the fact that it's commonplace for pension schemes to give more protection for the past service rights of pensioners than to the past service rights of actives. And the reason why active members' past service rights are typically given less protection is that active members are by definition below retirement age, and in the event of prejudice to their past service benefits, they still have the ability to accrue further benefits and thus replace any lost pension. It's important to be clear, however, because the representative beneficiary may be suggesting the opposite, that this disparity in protection between active and pensioner members that one sees in a variety of places, which I'll go to, and is commonplace, is not because these provisions are protecting future service rights of active members, and yet only the past service rights of pensioners are being protected. Almost no pension scheme or piece of legislation protects future service benefits. The disparity in protection seen in pension schemes and legislation instead relates to the past service rights of active members compared to the past service rights of pensioners. And a good illustration of such a disparity can be found in the context of the present scheme in the current winding up provisions, which are in Rule 18 of the current deed. Same point runs in relation to the 1949 deed, but I'll go to the Rule 18 of the current deed, which is at tab 10 of the supplemental bundle on page 215. And you can see that in the event of a winding up, the benefits of pensioners who have no possibility of earning further pensions post-winding up are accorded greater protection on the winding up than those of actives, in the sense that securing their benefits has a higher priority on winding up than securing the benefits of active members. This order of priorities at 215 ensures that active members don't get a penny in respect of their past service benefits until the pensioners have been paid their past service benefits in full. And that disparity in treatment on winding up plainly has nothing to do with the fact that the rights of pensioners being protected are past service rights, where the protection for members is in respect of future service rights. This is a winding up provision. A further example we give of the disparity in protection can be found in a statutory context in the current version of Section 67 of the 1995 Pensions Act, which is referred to at footnote 21 of our skeleton. I don't need, I think, to go to Section 67. As is well known, it protects pension benefits from amendment. However, it only protects past service benefits from amendment. That's what it's about. And despite this, it also provides a different level of protection for pension benefits in payment than it does for the past service benefits of active members. So, in particular, under Section 67, any changes to pensions can only be made with pensioner consent, but changes to active members, subsisting or past service rights, can be changed if actuarially equivalent pensions benefits are provided, even if there is no consent. And perhaps in the light of the discussions we've already had, it is worthwhile just taking the court to that. So if one picks up the authorities bundle, bundle 3, at tab 45, and turns to page 1062, you'll see that Section 67, subsection 2 provides any exercise of a power to make a regulating modification is voidable in accordance with Section 67G unless the following are satisfied in respect to the modification. And then it says, in the case of each affected member, 1, if the modification is a protected modification, the consent requirements have to be satisfied. And then 2, if that doesn't apply, Roman 2, if 1 doesn't apply, it's not a protected modification, either the consent requirements or the actuarial equivalent requirements. And if one then goes to tab 46 at page 1065, the next tab, you will see that included within the definition of protected modification is at B, a modification that might result in a reduction in the prevailing rate of any pension in payment under the scheme rules. So there you have a clear example of a disparity in protection in current legislation between the past service rights of pensioners and the past service rights of actives, in that you need consent in relation to pensioners, but in relation to actives, you can take their past service rights and modify them if what you produce is actuarially equivalent. So, given what we say is the prevalence of the policy of distinguishing between the protection offered to past service rights of actives and past service rights of pensions and claimant, we say there simply is no warrant for concluding that the differences in protection between the third and fourth provisos instead reflect the fact that future service benefits are protected under the third and not the fourth proviso. We say it's completely consistent with the fact that the third and fourth provisos both protect past service benefits like Section 67. The representative beneficiaries also suggest that it's inconceivable that the provisions about allowing a majority vote to reduce rights were only intended to apply to past service rights. Both the representative beneficiary and the trustee postulate what we would suggest are rather unrealistic straw man scenarios, whereby half the active members agree to vote away the rights of the other half. The first point to make about that is that, as both the representative beneficiary and the trustee acknowledge elsewhere in their skeletons, any such amendment could only be made, and therefore any such vote could only take place if the trustee, who would owe fiduciary duties to all the members, was persuaded that such an amendment was in the best interest of the scheme. Now, we say a scenario where half the members vote away the rights of the other half is simply not going to be one which gets the support of the trustee. The second point we make, in any event, is that, it's paragraph 7 of our supplemental skeleton, is that two can play at the game of imagining unrealistic straw man scenarios. So equally, on the construction of the interests favoured by the representative beneficiaries, it would equally be open to just over half the members to vote for an amendment which halved the future accrual rate of all the other members, but left their own future accrual rate intact. Clearly, the trustee wouldn't agree to that either, so such straw man scenarios really take us no further. More relevantly, if one confines oneself to more realistic scenarios, in my submission, there is no reason to believe that the draftsman could not have envisaged and intended that in an appropriate case it would be possible for members to vote on a reduction to past service benefits, which the trustee, by definition, would have already supported as being in the best interest of the scheme. Because if it didn't have the support of the trustee, there wouldn't be an amendment to vote on. In a sense, we obviously know that this must be the case because it's common ground that the third proviso does allow for amendment by past service benefits by a vote of members. And there's no particular reason to accept that the draftsman could not have envisaged that only past service rights could be amended in this way. We say that would merely be a consequence of the fact that he only intended to protect past service rights in the first place. And it's not hard in my submission to imagine examples of adjustments to past service benefits taking place which are much more realistic than the straw man scenarios dangled by the court before the court, by the representative beneficiary. So, for example, an adjustment to past service benefits could be to correct a genuine error in the past accrual rate. You could imagine it being dealing with a situation in which the scheme and the employer got into financial difficulties and the employment of active members could be put at risk. As your ladyship has already observed, there was no requirement when these provisions were originally drafted for the employer to fund any deficit. If one way of solving the employer's financial problems or sharing the deficit between active members was to cut past service pension costs, it does make sense that you would have a meeting of active members to sanction that benefit cut, because the alternative is that they might lose their jobs and their benefits. Furthermore, the submission that the draftsman of the third proviso cannot have had in mind that past service rights, or only past service rights, could be voted on, really, in my submission, fails to take account of the fact that when the third proviso was first drafted, it was generally accepted that past service rights could be amended, even if this didn't often occur. And you can see that from the Good report at tab 58 of Authorities Bundle 3, which is a little further on from the section 67. So the Good report was the precursor to the 1995 Pensions Act, which recommended the introduction of what became Section 67 of that Act, which we've already looked at. And the whole reason why the Good Committee considered Section 67 was necessary was that prior to this, many powers of amendment did allow reductions to past service benefits. And you can see this in a number of places. So, for example, at paragraph 3.2.9, at page 1127, it said, trust law allows the employer a wide measure of freedom in setting the terms of the scheme. It's for the employer to decide on the rules for entitlement to benefit, the employment and removal of trustees, and the distribution of powers and discretions between the employer and the trustees. The trustees may be given the widest powers to amend the scheme, even in relation to the accrual rate and the other accrued rights for past service, while the employer usually reserves the right to stop or reduce contributions, wind up the scheme, close it to new members, or freeze it so as to stop accruals in respect of future service. And we've obviously seen an example of that type of clause. This freedom of trust is to some extent reduced by social security and tax legislation, but for the most part remains unimpaired. And then if we go to 1129 and paragraph 4.26, members are currently entitled to scheme benefits, but only on the conditions set out in scheme documents and subject to the powers and discretions reserved to the trustees and the employer. As we've stated earlier, trust law as it stands allows the settler almost total freedom to write the rules of the scheme, control the appointment and removal of trustees, exclude or limit the liability of trustees, and prescribe the distribution of powers. The scheme documents may thus empower the employer and all the trustees, amongst other things, to reduce or even remove benefits or to attach more restrictive conditions of payment, even in relation to past service. And that was what caused the recommendation for the introduction of Section 67. And the point of referring to that is, one needs to guard against the unthinking assumption that in 1949, when these provisions were drafted, a power of amendment that allowed amendments to past service rights, but only if the trustee agreed, and only if a majority of active members were prepared to accept that change, would have seemed unusual or odd. The members would still have been doubly protected from adverse changes by those mechanisms. Now, although to modernise that may not look like a very attractive position, as I've endeavoured to explain, in circumstances where the employer is also under no obligation to deficit fund the scheme, you could imagine circumstances in which that would be an appropriate use of the power. And in my submission, it's not inconceivable, therefore, that that is what it was being intended to address. In fact, in my submission, that is what it was intended to address.
Are you effectively saying that because a lot of schemes allowed employers effectively to affect past service rights without protections, that this scheme conferred particular protections that might not have been generally available, hence the prompt for Section 67?
I'm not sure I go quite that. What I am saying, what I'm saying is that it's not true that members were simply at the mercy of an employer slashing their past service benefits under this clause. Firstly,
under this clause, yes.
Yeah.
But you're making a wider point about the pension position at the time.
All I'm referring to is what the Good report said about there generally being freedom to contract in this respect. I'm saying that the members of this scheme were not on the assumption it related only to past service benefits. completely denuded of protection. Far from it. They had the protection of the trustee having to agree to a variation of past service benefits, and they would only do so if they thought it was in the interest of the scheme as a whole. And they had the further protection then of having a meeting of their own class to vote any proposal endorsed by the trustee through. Is that a convenient moment?
Yes. So 2 o'clock, please.